Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the President.
Honorable Senators, leave of absence has been granted to Senator Dr. Muhammad Ibrahim, who is ill, and to Senator Anthony Vera, who is out of the country. Honorable Senators, I have received the following correspondence from Her Excellency the President, Paula Mae Weeks, ORTT. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Paula Mae Weeks, ORTT, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces. To Mr. Augustus Thomas, whereas Senator Dr. Muhammad Ibrahim is incapable of performing his duties as a senator by reason of illness. Now, therefore, I, Paula Mae Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Acting Prime Minister, do hereby appoint you, Augustus Thomas, to be a member of the Senate temporarily, with effect from the 6th of July 2022, and continuing during the absence of Senator Dr. Muhammad Ibrahim by reason of illness. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago, at the office of the President St. Anne's, the 6th day of July 2022. To Mr. Josh Drayton, whereas Senator Anthony D. Vera is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Paula Mae Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Josh Drayton, to be a member of the Senate temporarily, with effect from the 6th of July 2022, and continuing during the absence from Trinidad and Tobago of Senator Anthony D. Vera, given under my hand, and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's, this 6th day of July 2022. Honorable Senators are required to take the oath.
I, Augustus Thomas, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago, upon which I am about to enter.
I, Josh Drayton, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I'm about to enter.
Bills brought from the House of Representatives, as listed on the supplemental order paper, the Miscellaneous Provisions Criminal Proceedings Bill 2021 in the name of the Attorney General, and the Tobago Council for Handicapped Children Amendment Bill, and the Sri Satya Sai Baba Organization of Trinidad and Tobago Incorporation Amendment Bill 2022.
Honourable Senators, in accordance with Standing Order 62(1)B, the question is that the next stage of the Tobago Council for Handicapped Children Incorporation Amendment Bill 2022 be taken later in the proceedings. Those in favour say aye. Those against say no. I think the ayes have it. Honourable Senators, in accordance with Standing Order 62(1)B, the question is that the next stage of the Sri Satya Sai Baba Organization of Trinidad and Tobago Incorporation Amendment Bill 2022 be taken later in the proceedings. Those in favour say aye. Those against say no. I think the ayes have it.
Papers.
Minister of Social Development and Family Services.
Madam President, I have the honor to lay on the table the following paper as listed on the supplemental order paper in my name. The ministerial response of the Ministry of Social Development and Family Services to the second report of the Joint Select Committee on Human Rights, Equality and Diversity on the human rights of socially displaced persons in Trinidad and Tobago, with specific focus on their treatment and relocation from Port of Spain public spaces.
Reports from committees.
Minister of Trade and Industry.
Madam President, I have the honour to present the following report as listed in the order paper in my name. The second report of the Joint Select Committee on Foreign Affairs on an inquiry into the status of the CSME in Trinidad and Tobago, second session, 2021-2022, 12th Parliament. Thank you.
Senator Mark.
I have the honor to present the following report as listed on the order paper in my name. The sixth report of the Public Accounts Enterprises Committee on the audited accounts, balance sheets, and other financial statements of the East Port of Spain Development Company Limited for the financial years 2012 and 2013.
Minister in the Ministry of Agriculture, Land and Fisheries.
Thank you, Madam President. I have the honor to present the following report as listed on the supplemental order paper in my name. The report of the Joint Select Committee appointed to consider and report on the Fisheries Management No. 2 Bill 2020, second session 2021-2022, 12th Parliament.
Culture and the Arts.
Thank you, Madam President. I have the honor to lay on the table the following report as listed on the supplemental order paper in my name. The report of the Joint Select Committee appointed to consider and report on the Shipping Bill 2020, second session, 2021-2022, 12th Parliament.
Questions on notice, questions for oral answer.
Leader of Government Business.
Thank you, Madam President. Madam President, there are 3 questions for oral answer on the order paper, and the government is prepared to answer all 3 of those questions.
Senator Mark.
Yes, thank you, Madam President. Question 127 to the Minister of Finance.
Leader of Government Business.
Thank you, Madam President. On behalf of the Minister of Finance, Madam President, this question is extremely ill-advised and falls within a pattern of opposition questions on matters that they know are before the courts. It is a matter of public record, and Senator Mark is well aware, that the EFCL is the subject of an active winding up petition before the High Court of Trinidad and Tobago. And as a consequence, this matter is sub judice. In fact, there was a hearing in court on this particular matter as recently as Monday, 4th July 2022, which was well and widely publicized. As a result, no further statements can or should be made on this matter until the court proceedings are concluded.
Senator Mark.
Madam President, can you give me a ruling on this sub judice rule?
Senator Mark, I will not give any such ruling. It is well understood the steps and the appropriate action that is taken when it is announced that a matter is sub judice.
Can I ask through you, Madam President, whether the Minister is prepared to bring the Senate up to speed with the debts that are owed to contractors, consultants, and workers as a result of the closure of this company?
Senator Mark, that question is not allowed.
So, Madam President, is the government in a position to advise this Honorable Senate how it plans to address this decision and the outstanding sum owed amounting to $600 million? Can I ask that?
Senator Mark, that question is not allowed.
Can I ask through you, Madam President, whether the government can clear the air as to whether it is government's policy when they owe money to companies to get into what is called the winding up process in an effort to avoid paying their debts to consultants, contractors, and workers? Madam President?
Senator Mark, that question is not allowed. Next.
May I?
Next question, please.
No, I thought your mic was off because I didn't hear you. Can you know sometimes mine's switch off as well? Question 129 to the Minister of Labour.
Let me make sure my mic is on. Leader of Government Business.
Thank you, Madam President, and as always, I'm hearing you very clearly. A commission of inquiry has been established to investigate the circumstances that led to the deaths of 4 divers contracted by LMCS Limited to carry out pipeline maintenance work for Parier Fuel Trading Company Limited. Barring unforeseen circumstances, the procedural hearing of the Commission is scheduled to be held in August 2022, followed by the evidential stage thereafter. Madam President, it is quite likely that the Occupational Safety and Health Agency will be requested to participate in the inquiry in some form or fashion. In these circumstances, in order not to interfere with the mandate and/or work of the inquiry, it is not considered prudent. In fact, it is considered imprudent to make any statement regarding any investigation by the Occupational Safety and Health Agency into this tragedy until the Commission has completed its work.
Senator Mark.
Yes, thank you, Madam President. Madam President, can I ask the Honourable Minister whether he's aware, or put it another way, can the Minister advise whether the Occupational Safety and Health Agency conducted an investigation into this diving tragedy, and whether that, well, first of all, whether that has been done, Madam President?
Senator Mark, based on the question posed by you, which question begins with the words, given the investigation launched by the Occupational Safety and Health Agency, I will not allow that question.
Can I ask the Minister whether that report that was commissioned or launched by the Occupational Safety and Health Agency, can the Minister give us an understanding of the status of that report? Has that report been completed, Madam President?
Senator, Leader of Government Business.
Madam President, the language of the Senate and the Parliament is English, and I really thought that I was pellucidly clear on this particular issue. There is a clear position of the government of Trinidad and Tobago to avoid prejudicing the mandate and operations of the Commission of Inquiry. The supplemental questions that Senator Mark is seeking to lay and the line of questioning he's seeking to initiate takes us exactly into that direction. And in the primary answer to the question, I made the government's position on this matter completely clear.
Senator Mark.
Madam President, can the Minister indicate whether the government is using the Commission of Inquiry as a fig leaf in an effort to escape accountability, transparency as it relates to this diving tragedy that occurred some time ago?
Senator Mark, that question is not allowed.
Madam President, seeing that the Minister has been talking about Commission of Inquiry and procedural hearing, is the Minister in a position to tell this Parliament, the Senate, precisely when will the Commission of Inquiry begin, particularly in the context of what he has shared with us earlier, and given the urgency of this matter, can he now share with the Senate when does the government expect this Commission of Inquiry to commence, particularly, as he said, procedural aspects.
Senator Mark, that question is not allowed. Next question.
Why are they switching you off? I'm very concerned. Every time you try to talk, the mic is being switched off. I have to come to the defense of my president.
Next.
Are you trying to muzzle the president?
Senator Mark.
Allow the president to speak, please.
Senator Mark.
Madam President, I will proceed in your defense.
Thank you so much, Senator Mark. Next question,
Madam President,
please.
question number 130 to the Minister of Energy and Energy Industries.
Leader of Government Business. Oh, Minister of Trade and Industry.
President. The health, safety and the environment function is managed internally by PARIA. However, specialized HSE services are contracted to provide effective and efficient support to the PARIA team, thereby minimizing risk exposure.
Senator Mark.
Ask the Minister to elaborate on the specialized areas of health and safety that are currently being outsourced.
Minister.
As I said before, the function is managed internally by PARIA. However, it's only in particular circumstances that services will be contracted to provide support to the team, and that is risk associated.
Madam President, I'm becoming a bit concerned when ministers do not come here and other ministers respond.
Senator Mark,
and they can't
please,
adequately...
Senator Mark, please ask a question.
Minister, to be more concrete and specific as it relates to the particular circumstances that would allow PARIA Fuel Trading Company to outsource the health and safety function that the minister said is carried out by the said company. Can we get some concrete circumstances?
Senator Mark, that is a repeat of the question the supplemental question you asked, and an answer was given. So can you ask another question, please?
Can I ask you to identify the name of the company or companies that are engaged as it relates to the outsourcing of these services, Madam President?
Senator Mark, that question is not allowed.
But if we are being told...
You have one more question.
Thank you. Can you guide me on this before I ask? If we are being told, Madam President, that the matter is things are being outsourced, circumstances permit outsourcing, I am asking a logical follow-through as a result of it. Can the minister advise you, and through you, this Honorable Senate, as to the companies that are being used for purposes of outsourcing these particular functions?
Senator Mark, that question does not arise based on the question that had been posed and the answer that has been given. So I think you have finished your questions. Supplemental.
Motions relating to the business or sittings of the Senate and moved by a minister.
Leader of Government Business.
Madam President, having regard to the report of the Special Select Committee of the Senate, appointed to consider and report on a code of ethical conduct and behavior for senators, second session 2021-2022, 12th Parliament, and the time constraint realized by the committee, I beg to move that in the third session of the 12th Parliament, a committee be re-established to consider and report on said code of ethical conduct and behavior for senators.
Honourable Senators, the question is that the third session of the 12th Parliament, that in the third session of the 12th Parliament, a committee be re-established to consider and report on the code of ethical conduct and behavior for senators. Those in favour say...
standing order, that particular motion is being moved, because I know that you can save reports, but this particular matter, I think we need to be clear that we are not breaching or violating our standing orders. So if the Honorable Leader of Government Business can tell this House under which standing order you are moving that motion for adoption, I think the record is going to be very, very important here, because I don't know. I ask for clarification.
Senator Mark, we will treat with that. I will have a discussion with you later in the proceedings. Honourable Senator, the question is that in the third session of the 12th Parliament, a committee be re-established to consider and report on the Code of Ethical Conduct and Behaviour for Senators. Those in favour say aye. Those against say no. I think the ayes.
Dr. Brown?
Yes.
Mr. Armour?
Yes.
Ms. Gopi School?
Yes.
Mr. Sinema?
Yes.
Mr. Hussain?
Yes.
Ms. West?
Yes.
Mr. Mitchell?
Yes.
Ms. Cox?
Yes.
Mr. Bacchus?
Yes.
Mr. De Freitas?
Yes.
Mrs. Sagram Singh Sukla?
Yes.
Mr. Singh?
Yes.
Mrs. Lazama Leasing?
Yes.
Mr. Hislop?
Yes.
Mr. Thomas?
Yes.
Mr. Mark?
No.
Ms. John?
No.
Ms. Lutchmedial?
No.
Mr. Nakin?
No.
Mr. Lyder?
No.
Mr. Roberts?
No.
Mr. Richards? Ms. Dionarine?
Abstain.
Ms. Sipasad?
Yes.
Mr. Timal?
Yes.
Mrs. Thompson-Ahi?
Yes.
Dr. Dillon Remy?
Yes.
Mr. Welch?
Yes.
Mr. Drayton?
Yes.
Madam President, the result of the division is 22 senators voted in favor, 6 against, and there was 1 abstention.
Honourable Senators, the result of the division is as follows. 22 senators voted yes, 6 senators abstained, and 1 senator abstained. The motion is therefore carried. Leader of Government Business.
Madam President, in accordance with Standing Order 77-3, I beg to move that the following bills be restored to the order paper in the third session 2022-2023 of the 12th Parliament. 1. The Fisheries Management No. 2 Bill 2020. 2. The Shipping Bill 2020. 3. The Private Security Industry Bill 2022. And 4. The Supplemental Police Amendment Bill 2022.
Honourable Senators, the question is that in accordance with Standing Order 77-3, the following bills be restored to the order paper in the third session 2022-2023 of the 12th Parliament. The Fisheries Management No. 2 Bill 2020, the Shipping Bill 2020, the Private Security Industry Bill 2022, and the Supplemental Police Amendment Bill 2022. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
Public Business, Government Business Bills, second reading.
Honourable Senators, the second reading of the following bill which was adjourned on Monday, July the 4th, 2022, will be resumed. A bill entitled An Act to Amend the Bail Amendment Act 2019, Act number 17 of 2019. There have been some 20 speakers on this bill already, and Senator Lutchmedial.
Thank you, Madam President, for the opportunity to contribute today in this debate. Madam President, before us today is a bill which seeks to extend the life of an act that was passed in 2019. And it is important for us to understand exactly what the 2019 law was meant to accomplish and the ramifications of that 2019 law in real and meaningful terms, if we are to understand why it is, and if the population particularly is to understand why it is, we will not support this measure. Madam President, the 2019 law, which has been in effect for 3 years, coming up on 3 years, does not, contrary to the narrative that is being created, does not just target repeat offenders. In order to be a repeat offender, you have to be first convicted of an offense. And then you repeat and you come out of prison and you commit another offense. But this bill that was passed in 2019 goes beyond that. There's one section, the first part of the provision, deals with a person charged with an offense under Part 2 of the first schedule who has been previously convicted. But under Section 5(3), Madam President, a person who has a pending charge and is again brought before the court on another charge, an accusation, will automatically be denied bail for 120 days, which I understand some people in listening to the debate before didn't think that was very long. Well, I spent about half an hour in a prison cell in remand yard once upon a time on a visit. And that was the longest half an hour of my life. And to this Parliament to stand here today in the context, and I will get into the context because a lot of time has been spent talking about the context and the situation that we are in right now as a country. But in the context of where we are, having had this law in place for 3 years, to put someone in prison on an accusation, whether it is 1 or 2 accusations against them, having that person never having their day in court to mount a defense, is unconscionable, it is unjustifiable, and I dare say it is unconstitutional and illegal, and I will get to that, and why judicial developments have to be taken into account with this bill today. Madam President, the law as it stands today on the 6th of July in this country is that any attempt by the legislature to interfere in the grant of bail by the judiciary is illegal, unconstitutional, and a violation of the separation of powers. And I cannot understand how, in light of what has happened in the course of our judicial development since 2019 to now, the government could be asking us as a parliament to join hands with them and pass an illegal law. They are asking us to come here and work with them to pass a law that is liable to be struck down. Madam President, it does not matter where there is an appeal or what is an appeal. There is a ruling that is the law of the land, the doctrine of stare decisis that you learn on the first day that you enter your LLB program says that unless a ruling is overturned, it is the law of the land and we must abide by it. And the law of the land right now is that it is not reasonably justifiable in a country with due respect for the rights and freedoms of individuals for Parliament to legislate away what is a core judicial function. What the attempt by the government here today, by bringing this bill, they are trying to camouflage their abject failure in dealing with the crime situation. And not just the crime situation alone, because it is not just on crime that they have failed, and several of my colleagues have gone through the trouble of identifying how other failures are contributing to the rise in crime. They are failing in education. They are failing in the management of the economy. And all of these things contribute to the rise in crime. So as they fail on this side and they fail on that side, they come to ask us now to pass an unconstitutional piece of legislation. Because I don't know, apparently passing law now is like a make-work program for attorneys who will get briefs from the state, because this will be challenged, and I dare say, and God so help me, I will be part of the challenge to this piece of law if it is passed today. And it will be struck down. Because in light of everything, I don't know if anyone who has come here in support of this piece of legislation today has read and has followed the development of the law from 2019 to now. And with the greatest of respect to Senator Richards, he asked what has changed in the part of the opposition. What has changed is that the court has ruled on the issue of bail being a judicial function, and it is not Parliament's place to interfere with it. So what the government should have been doing, instead of having us here for 2 days talking about the state of crime in this country, because that is all I have heard from the government bench, and I follow the debate very closely. That is all I have heard from the government bench, how bad crime is in this country. What they should have been doing is looking for alternatives to dealing with crime, not coming here to just revamp the same thing that has not worked for the last 3 years, which has now been deemed unconstitutional by the courts. That, Madam President, represents an admission of failure. It represents intellectual bankruptcy, and I think that the government have simply, they are just simply ready to give up if this is the only thing that they can really bring to this Parliament and to the country to say that they are dealing with the crime situation. So, Madam President, the government's solution is that once a person is accused by the police of committing a certain list of offenses, any of those offenses, you must throw them in the prison and lock them away. It is like out of sight, out of mind, and that is supposed to give the population some kind of comfort. That is supposed to give the population comfort that the government is prepared to ride roughshod over the constitutional rights guaranteed to every citizen of this country to say that it is a mechanism to treat with crime. And the judiciary is replete with judgments that anybody is free to go and research and read that says that the core function of bail is not as a crime-fighting tool. It is meant to secure attendance to court. It is meant for the protection of witnesses where a threat exists. It is meant to ensure that that persons do not reoffend if it is that they are susceptible to doing so. And the point that no one is grasping is that all of the objectives that the government say they need to achieve by this bill are things that judicial officers are empowered to and mandated to deal with by Section 6 of the Bail Act. Section 6 lists all of the criteria that the judicial officer must take into account if they are going to grant bail. And that includes the risk of reoffending. It includes whether or not a witness will be threatened. So the judicial officer, on the first occasion that a person is arrested and brought before them, has the opportunity to offer the country and the citizens, and as I heard repeated over and over, the young men and the young women and the elderly and everybody else, or the government trying to be emotive about this matter, the judicial officer has every opportunity to offer protection where it is warranted. And I do not understand why the government feels it is their role or the role of this parliament to remove that opportunity from the judicial officer. There is absolutely no evidence presented by anybody on the government bench to say that we have had irresponsible judicial officers granting bail to persons. None. None whatsoever. And it is really an affront to our democracy. It is an affront to the basic concept of separation of powers enshrined in our Constitution that the government will, in light of what has been said by the courts in this country about separation of powers and what is a judicial function and what is the role of the judiciary as opposed to the legislature, that they would ask us to pass this bill here today. Madam President, the purpose of a sunset clause, as was included in the 2019 bill, is so that you can assess the efficacy of the bill. And I think that the editorial in today's Express, I could have just read this as my entire contribution because it is so on point and it is so accurate, because it speaks about the very serious concession given to the government in 2019. The parliament sat here and agreed. The opposition gave you the opportunity. You say you need a tool. You need the tools to fight crime. You have had the tools for 3 years. And what do they say has happened? And I want to quote from that editorial, today's editorial, 6th of July, 2022, in the Trinidad Express, page 12. Neither the government nor the police seem to appreciate the huge constitutional concession made by the parliament in agreeing to deny bail for 120 days to persons charged with certain offences while the police build a case against them. In agreeing to this draconian steps 3 years ago, the parliament accepted the government's argument that this constitutional ammunition was necessary for bringing rising serious crime under control. It goes on. The fact that gang warfare and killings are today out of control is tangible evidence of the failure of the Bail Amendment Act 2019 to deliver on its promises. So, Madam President, the entire country. I read an article by quoting former Attorney General Ramesh Lawrence Maharaj, distinguished senior counsel, saying this is not the way to go. I read this editorial this morning. It is not the way to go. I read comments from criminologists from the university asking where is the evidence that this bill is working. And in listening to the contribution of members opposite, I heard the minister in the Ministry of the Attorney General spend some time on statistics. Oh, Madam President, I think that between the Honorable Minister and the Attorney General himself, they have made our case for us here today. The Attorney General, firstly, when he talks about the test and what must be done here today, he quoted the Dominic Suraj judgment, which confirmed the case of Surat and the approach to be taken. It says that we must ask ourselves today whether the bill strikes an acceptable balance between the rights and freedoms of the individual and the community at large, and that is true. How do you, otherwise the act is liable to be struck down, even if it passes with the 3/5 majority, which I really do hope, and I urge all members not to give a majority on this bill today. And I will tell you why. Apart from it being unconstitutional, Madam President, we have to look at what it has accomplished. And in dealing with the statistics, apart from admitting that the state of crime today that we live in Trinidad and Tobago is frightening, and it is serious, and that today we have absolutely no control over what is happening in this country, they have missed the point entirely. That for the last 3 years, having these powers, nothing has been accomplished. So all of those things have to be taken into the mix when you are weighing the proportionality of this measure. What has it accomplished? Nothing. And let me talk to you about a little bit about the statistics. This bill was passed in 2019, so middle to, or somewhere August 2019, so halfway through the year or more than halfway through. So let's forget 2019. The same statistics quoted by the minister, I don't know if where the minister in the Ministry of Interior got her statistics. I got mine from the CAPA Crime and Problem Analysis Unit website of the TTPS, which is there for everybody to check. Murders in 2020, let us do a comparison from 2020 and 2021. 2 full years when these provisions that they are seeking to extend today were in effect. The police had the tools, as they call it, that they claim to need to bring crime under control, and add to that in the mix that we had a state of emergency that restricted people's movements and so on sometime during that period in different times. Murders went from 393 to 448. Now, every time the minister quoted a statistic, I noticed she paused to say, we're not where we want to be, you know. We're not where we want to be. Madam President, it's not that we are not where we want to be. We are worse off. We are worse off than where we were. We are heading towards 600 murders for this year with this law in place. I noticed that people stay away from percentages. Now, I know lawyers aren't very good at math, but there's an app for that. We had a 13% increase in murders from 2020 to 2021 while this law was in effect. Woundings and shootings, that is how it is classified by CAPA. Woundings and shootings went from 401 to 610. Everybody and their grandmother. I literally read an article by one of the young men shot over the weekend. His mother is saying she's appealing for them to deal with the guns coming in the country. Even a mere civilian who has lost their child could have the coherent thought to identify the problem as being guns coming into the country. But the government is coming here to tell us about bail when they are doing nothing to arrest the situation of guns coming into the country. And when we look at woundings and shootings, you have a 52% increase in the numbers from 2020 to 2021. And they come to tell us today that crime is down and this is a tool that the TTPS needs and therefore we must extend it. And when you look at the detection rates in simple numbers, it's very easy to use statistics to fool people, you know, because the Honorable Minister is saying, well, 111, well, I don't know, I can't remember the statistics she quoted, but if you look at it, yes, 111 detections for woundings and shootings in 2020, and that went up to 132 in 2021. But, Madam President, if you look at it in percentages, according to the amount of crime you have, you went from a detection rate of 27% in 2020 to a detection rate of 21% in 2021. So while crime and the incidence of crime rising, the detection rate by the TTPS is actually falling. And that is the basis upon which the government comes here today to tell us that they need this piece of legislation to fight crime. When for 2 whole years, January to December 2020 and January to December 2021, with this law being in effect, these are the results. Sexual offenses, rape and serious indecency went from 386 to 382. So that went down slightly. Larceny went from 1,283 to 1,500, Madam President, a 16% increase. And these are some of the offenses that we are saying if a person is accused of on 2 occasions by the police, without ever having their day in court, we must throw them into remand yard for 120 days. And up to a year if the prosecution come and release one witness to say, yes, I was there and this is the person and I arrested the man. That is all it takes, you know. That is all it takes for the prosecution to start its case. It could call one witness, and the case has started, and a person who is supposed to enjoy the presumption of innocence will be remanded into remand yard, which judicial officers in this country have written judgments describing as a hellhole. And we will put someone in there for 1 year on a mere say-so of the police without a judicial officer ever hearing one scrap of evidence. Tell me how that is reasonably justified in a society where crime is rising and detection is falling when the law is in effect. Explain that to me and to the population, Madam President. That is what the government must do here today. And that is what they have spent an entire day here. Some 20 persons have spoken, and not a single person on the government bench can show us how it has helped. What would have helped? And perhaps in his winding up, the Attorney General can tell us how many of the persons denied bail in the last 3 years, when they were arrested, have the government recovered firearms and taken firearms off the streets? How many of those persons denied bail for 120 days or up to a year have actually been convicted of any criminal offense to date? A man could have been arrested in 2019 and spent 3 months in prison. And as of today, he is still, in the eyes of the law, innocent. Or he could have spent a whole year in prison because his case has started. But in the eyes of the law, he is still innocent. This attempt to remove the judicial discretion to grant bail and to automatically deny bail to persons who have never been convicted of an offense makes a mockery of the presumption of innocence. And the presumption of innocence is a cornerstone in the foundation of our criminal justice system. If we lose the presumption of innocence, Madam President, we might as well just take our entire constitution and throw it in the dustbin. It is disrespectful to the constitution of this country for us to pass a law that makes such a mockery out of the presumption of innocence. It makes a mockery of our democracy to say that on the mere say-so of a police officer who says that a firearm was involved in a matter, in an alleged crime, allegedly committed by someone before the court, that they must be denied bail. That is basically saying that we have no belief, none whatsoever, in our judiciary. It is saying that we have no respect for the rule of law. It is saying that we have no respect for the rights of persons to make a case before a judicial officer. And I don't know about anybody else, but I am not prepared to stand here and say those things. And the opposition is not prepared. In 2019, they lobbied very hard against the opposition. And the government has a tendency, every time there is a spate of crime, to blame it on the opposition's lack of support for legislation. So in 2019, we gave it to them. We gave them the opportunity, and they have absolutely nothing to show for it today. Not one single accomplishment. When we are getting back to the process of weighing the proportionality of these measures, Madam President, it is quite simply inescapable for us. You cannot avoid asking yourself what else could be done. What else could be done, and what other options are available other than taking away people's rights or deferring them, as I heard one member opposite say, because apparently that seems more acceptable. That I could take away your rights today for 3 months and that's okay, but I'm not taking it away, just for 3 months. I want to know if it is that you could say to somebody, well, I will take away your property for 3 months.
Senator Naked, you made a comment earlier, I ignored it. Please stop it, all right?
Yes, thank you, Madam President. If you are taking away someone's property today, can you tell them, oh, don't worry, I will just take it for 3 months and that's okay? But you are taking away someone's liberty for 3 months. And when you are looking at the proportionality of that measure, apart from its success for the last 3 years, we have to consider the conditions in remand yard. Madam President, this government has brought evidence of the cost of keeping someone on remand yard. And when I went back into the archives and I recalled that it was the Honorable Attorney General talking about the 60% of the prison population being on remand and $20,000 to $25,000 a month to maintain someone at remand yard. You know what it triggered in my mind? It triggered in my mind a memory of an affidavit filed in a matter before the court, which was already heard, an application for a stay on the grant of bail. And the head of the electronic monitoring unit in this country said that they were unable to fix electronic monitoring devices on all the persons who are eligible for bail as a result of the court judgment because they didn't have enough devices. And a device cost $12,000. One prisoner One person, and that is a matter of public record, anybody could go and check it. That is the affidavit evidence that the state put in. So one prisoner in remand yard for a month could purchase 2 electronic monitoring bracelets. And that not only frees up the space in the remand yard to keep persons who actually pose a threat to society and who a judicial officer determines ought to be placed there, but it also creates a number of opportunities, Madam President, to preserve the social fabric of a person's life who is innocent in the eyes of the law. Persons here, I don't know how many people here have ever interacted with someone charged with a criminal offense, but I feel it is my duty, having sat on both sides as a prosecutor and a defense attorney, to put the facts, the raw, simple facts before this court. That when a person is denied bail, what happens to them? If they are kept in prison for 3 months or 1 month or 2 weeks, and they cannot pay their rent, they are thrown out of where they live. Their relationships, familial bonds break down. I remember one time a man in tears. He was a repeat offender. And that's okay. Every sinner has a future. Every saint has a past. He was a repeat offender. Yes. And I sat there and I listened to him and I said, well, you are charged again with robbing someone. Why? Why are you here again? Why would you do something like this? And he said to me, I was denied bail. I spent my 3 months until I was eligible to bail. Even after that, I had problems accessing bail because of the amount, but eventually I came out. By the time I came out of remand yard, my wife left me, but she put me in court for maintenance. There's a court order saying that I must maintain my children. My employer fired me because I was missing in action for 3 months. So the little job that I was able to hold down before and earn an income, I was not getting it anymore. I have to live. What do you expect me to do? You see, our prison system is inextricably linked to the issue of bail. And the absence of any sort of rehabilitation or any sort of program to manage offenders is why the restriction on bail is so disproportionate. Because what you are doing is you are going to take people off the street who supposedly enjoy the presumption of innocence, keep them in the prison for 3 months, and then unleash them onto the population where they are unemployable, having spent 3 months inside the prison, lose all manner of support that they may have had before being arrested. When a person is arrested and they are brought before the court and they eventually are granted bail, provided that they can access the bail and they have a bailer, they are able to go back into life within a week maximum, let's say. But when you keep someone in prison for 3 months and then they are allowed to come back out, because we all know the chances of starting a case in 3 months' time is slim to none, or 4 months. So what happens when you put them back out there? You are putting them back on the pathway to crime. And again, Senator Richards asked about what has changed. Well, Senator Richards sits on the same Joint Select Committee that I sit on. And at a public hearing dealing with the prison system and gangs in Trinidad and Tobago, we heard evidence, and it was widely reported in the media, that the prison is the place where gang recruitment takes place. And persons appearing before that committee said that special attention should be placed to remand. So when you decide now that a person who might be in problems with the law, never convicted, but in trouble with the law for a second occasion, must go into remand yard and must stay there for 3 months, what you might actually be doing is putting them directly into the feeding ground of the gangs in Trinidad and Tobago. Gang recruitment happens more in remand prison in this country than outside of the prison, and that is a fact. So when we are looking at the proportionality of this bill and the government's move to arrest the crime situation, the government is taking someone who might be an undergraduate in crime and getting them after 120 days to come out with a PhD in crime as a seasoned gang member and unleashing them back on the population. I don't understand how, with all of the evidence, anecdotal, Joint Select Committee, media, and what every man, woman, and even some children on the street know and understand to be the circumstances that exist in the prisons in Trinidad and Tobago, this government could actually convince themselves, because I don't think they've convinced anybody else, but convince themselves that this law has any merit in it whatsoever and can accomplish anything. This law is simply a failure. It is an utter failure. Madam President, the fact of the matter remains that our Constitution grants people not a right to bail, but a right to apply for bail. The courts are perfectly capable of protecting the public interest. Those are the words of the Chief Justice in rendering his decision on a matter involving the constitutionality of bail restrictions. The removal of that discretion, Madam President, from the judiciary is not a solution to crime. And we stand here week after week, month after month, every single time a piece of legislation is brought to this parliament dealing with any aspect of crime, and we give the government proposals, we talk about the solutions, and it is their fault, and it is as a result of their implementation deficit that we have no DNA testing, we have no progress on forensic matters, we have no electronic monitoring, we have no parole system that they have promised us. And that is why crime is out of control. We have very little border control to intercept the influx of firearms, and that is why crime is out of control. It is not because people are getting bail, because people have not been getting bail for the last 3 years, and they have absolutely no evidence to show us that this has made an impact in this country, Madam President. We have gone from bad to worse, and I will not participate in something that is not only a failure, but it is illegal, it is unconstitutional, it is doomed to fail if it goes before the court, and it will go before the court if it passes. I give them that assurance on behalf of the opposition of this country. I give them the assurance that if this bill is passed and it becomes law, it will be challenged before the courts in this country. And I am well placed to give that assurance. I do not understand how a government that has failed to implement any meaningful measure to address recidivism and repeat offenders by having a system in place to manage people when they exit the prison system can actually think that denying bail to persons when they are charged is a solution to crime. I cannot understand how a government faced right now with an education crisis where children are simply without opportunities in this country could think that restricting bail and throwing them in a prison where we just don't have to deal with them. Like I say, it is out of sight, out of mind. It is the equivalent to, I don't know if you recall when we were having, I don't know if it was the Summit of the Americas or CHOGM, that they built a wall.
Senator Lutchmedial, just 1 second.
I think it's going a little wide.
Senator Lutchmedial, continue.
Thank you, Madam President. Madam President, you see, going wide and dealing with the government's failure on crime is essential because it is the government's failure on crime and the failure to deliver on every single promise that they have made in the economy, education, crime, everything else. That is why we have an out-of-crime situation that they are attempting to remedy by throwing people into remand yard. And yes, as I was saying, it is the equivalent of when they built a wall along the highway when President Obama was visiting. It's like you could just block it out. We don't have to look at it. That is the equivalent of what they are trying to do now. They are trying to block out, and we don't have to deal with these prisoners because, listen, the law is there to throw them into remand yard. And that is the solution that they want to come with here today and tell us that that is the solution to crime. Madam President, when you look at proportionality, and very quickly, I just want to deal with this. If you have to deal with proportionality, could you just let me know how much more time I have?
You have 7 more minutes.
Thank you, Madam President. That is enough for me to go through some of the judgments, none of them under appeal, because I know that if I say anything about judgments which are under appeal, they will jump up erroneously on the sub judice rule. But I will deal with judgments that have dealt with prison conditions in this country, Madam President, because it is absolutely necessary when weighing the proportionality of a bill that will put someone who has the presumption of innocence into remand to understand what that means for an individual, what they are going to be subjected to for the 120 days at the behest of this government. I refer to the case of Colin Edgehill and the Attorney General in 2008, Madam President, where the Honorable Justice Gobin quoted extensively from other pieces of from studies and so on in the prison. And the Honorable Judge stated, and I quote, "The remand yard, Port of Spain, is a hellhole in which a man presumed innocent is deprived of the elements necessary for human life: air, light, sanitation, hygiene, exercise, and even food. The level of pain and suffering inflicted during detention goes beyond the harsh, or what is, to my mind, can conveniently be described as mere unacceptable and unsatisfactory. The treatment makes a mockery of the presumption of innocence." Madam President, the government are asking us today to pass a law where an innocent person could be subjected to those conditions. In the Privy Council judgment of Terence Calix versus the Attorney General, Madam President, they describe the prison conditions at the Golden Grove prison. And they talk about the Inter-American Court of Human Rights report into detention.
Senator Lutchmedial, you have 5 more minutes.
Madam President, cells of dimensions of approximately 9 feet by 6 feet are shared by up to 7 or 8 prisoners. Sleeping facilities are inadequate with only 1 double bunk in each cell. Consequently, many inmates are forced to sleep on the floor on a thin piece of worn carpet which is never cleaned, or on a thin sheet if provided by relatives. Cells are poorly ventilated, are hot and uncomfortable. Lights may be kept on all night. A single plastic pail. I don't know if everybody here has ever understood the concept of a slop pail, but that is what you have in remand yard. A single plastic pail is provided for use as a toilet by all the detainees in the cell. Madam President, the government is here today to tell us that any person on the mere say-so of a police officer, a person who never has the opportunity to mount a defense to an accusation against him, a person never convicted of an offense but accused on 2 occasions of a crime by the police, who have absolutely never presented any evidence before a judicial officer, will be subjected to those conditions for 120 days. And that is what this government thinks is the solution to crime. That is a solution to psychologically create a criminal. That, what the government is proposing here, is what will force people to come out of there in 120 days and be angry at the world. Madam President, I have spoken in this parliament before when I was a prosecutor of making several applications for someone to be denied bail for a sexual offense, on the ground that they were, because they had the age of the victim and so on. And do you know that after some 7 years of that person being in prison, the victim admitted to lying? The victim was trying to hide a relationship with someone else by whom she had become pregnant, and pinned it on someone who had given her a drop home. On those simple accusations. And you know why I call them simple accusations? Because the criminal justice system and prosecutions in Trinidad and Tobago are still reliant on the say-so of witnesses who are inherently, in some cases, unreliable. Human beings are not scientific evidence. So when a person spends 120 days or up to a year in prison, by the time their case comes before a jury, in 5 years or 10 years, witnesses could recant. And the witness could say, look, I lied. And what happens then? You have taken away a person's life. The matter that nobody wants to talk about, where the Bail Act was found to be in violation of separation of powers. A man was deprived of his life for 9 years under these conditions that I have described. 9 years, Madam President. And what did it accomplish? Absolutely nothing. And in winding up, I want to say, I heard a member opposite say that the 120 days in certain cases could afford the police the opportunity to investigate. Madam President, if the government thinks that the answer to crime is to make police inefficiency permissible, well, they are severely misguided, and we cannot, on any circumstances, condone that. And I want to strongly condemn any suggestion that a person should be charged and brought before the court in Trinidad and Tobago and remanded into custody while the police go about collecting evidence. You are supposed to collect and have sufficient evidence before you charge someone. And if we had a working criminal justice system where you could go before the magistrate on the first occasion and say, we have retrieved fingerprints that links this person to the crime. We have DNA evidence linking this rapist to this particular victim. We have in our possession CCTV camera footage that places the person on the scene of the crime, committing the crime. The judge or the magistrate would deny bail because it is the strength of the evidence. And people who have never appeared in a court and who have never heard a bail application made do not understand that the first inquiry a magistrate will make is about the status of the victim and the evidence that the police have against the offender. And if the police and the prosecution were given the resources to be able to do that, we would not need this piece of legislation, Madam President. So this plaster is meant to hide and it is meant to cover the gaping wound created by the government's failure to address every single aspect of the criminal justice system. And Madam President, for those reasons, we will not support this bill and the extension of these draconian measures. I thank you.
Minister of National Security. Minister of National Security.
I thank you very warmly, Madam President, for recognizing me from the other place to come to make a short presentation in this very important debate and the matter that is in front of us. I thank you very much for that. And I thank honorable senators for entertaining me as politely and beautifully and professionally as you all have. The last time I was here, Madam President, it was to pilot the anti-terrorism law, and there were doubters in the society at that time, somewhere around 2005, 2006, who said that we did not need anti-terrorism law in Trinidad and Tobago. But I lived to see that terrorism remains one of the world's, including Trinidad and Tobago's, enduring threats. And I live to see from my own knowledge that we averted a major terrorist event in this country, one Carnival Sunday night, just a couple of years ago. And when I saw that, and I was present in the grandstand on that night, I thank God that we passed that law, and we have other laws that would have allowed us to protect the people of Trinidad and Tobago from that and averted that attack. Today, Madam President, I am here not only as a member of Parliament, not only as the Minister of National Security, but as an emissary on behalf of the people that I represent, on behalf of the people that we all in this honorable House represent, the voiceless people in the society, on whose behalf we are privileged, nominated, elected to speak in this place. And for that reason, I propose to take a selfless, non-egotistic, empathetic posture in the context of this very important debate. Madam Speaker, I followed some of these discussions from my chambers, the Office of the Minister of National Security, as well as I could have on Monday, and listened to some of the presentations made, which is what prompted my presence here today. I am satisfied from all that I heard that the terms of the measures before us are sufficiently clear, and I need not rehash them really for the purpose of the honorable senators. But I am speaking to the voiceless people who have sent me here to speak on their behalf. So let me simply say that the measures before us relates, Madam President, to measures to restrict bail in circumstances where a person has been convicted of an offense that carries a penalty of imprisonment for over 10 years and is then charged for an offense stipulated in Part 2 of the first schedule of this Act. And let me very quickly say what those offenses are. An offense committed by a person over the age of 18 under the Anti-Gang Law, an offense under the Offences Against the Persons Act, which is punishable by a term of 10 years or more, an offense under the Dangerous Drugs Act, which is punishable by a term of imprisonment for offenses for 10 years and more, an offense under the Kidnapping Act.
Madam President, 53-1, tedious repetition. This was fully
Senator
rehashed
Leiter,
by the
please.
Attorney General.
Senator Leiter. Minister, continue.
A sexual offense which is alleged to have been committed where the victim is a child. Sexual offense is an offense under the Sexual Offences Act, an offense under the Anti-Terrorism Act, an offense under the Trafficking in Persons Act, an offense under the Firearms Act. And any attempt to commit any of those offenses, as I have just described them. And that was for the benefit of those outside of this chamber who may have missed it, on whose behalf we speak today. The second category is a person who has a pending charge for firearm, ammunition, or prohibited weapon, including hand grenades and automatic weapons. And that person is charged under Section 6 of the Firearms Act, meaning to say they are in possession without explanation, without license, another firearm. And Madam Speaker, the third category is where you have a pending charge for an offense specified in the list I have just gone through. And now you are charged with another offense from that list of serious offenses. And finally, an offense listed where you are charged for an offense as I have just described, and you are now alleged to have used in the commission of a crime, whether it's rape or robbery or kidnapping, another firearm, all very serious offenses, all requiring or permitting the judges to give you a sentence of 10 years or more. And in addition to that, you are unable to get bail in the restrictions that we discussed today if no evidence has been offered by the prosecution after a period of 120 days. All of these, if you look at them carefully, are designed to deal with repeat offenders, persons who have the proclivity, Madam President, to offend and offend and offend again, even they've been charged and they're on bail already. These measures today, I heard the senator who spoke before me talking about the government. I want to make it clear to the learned senators of this House. This is not about the government. This is not about me. This is not about you as individuals. This is a matter for the police. And more directly, this is a matter to protect the people of Trinidad and Tobago, the public on whose behalf we speak today. Having listened to some of the debate in this place, I have listened, Madam President, to the call for statistics, information, quite properly so, to allow senators to do the balancing of the interests that we are obliged to do. This is not about a party position. This is not about government or opposition. This is the Parliament of Trinidad and Tobago having to make a serious decision, not even on our own individual behalves, but on behalf of the people who are voiceless, on whose interest, on whose basis we speak. So let me just share some statistics, Madam President. And these come from the Criminal Records Office of the Trinidad and Tobago Police Service. They manage these matters on a daily basis, and I cause them to collaborate with the Trinidad and Tobago Prison Service that holds and keeps records and individuals in their care. And I therefore offer you, senators, who wanted some statistics from the criminal, not CAPA, they keep statistics, but not this, from the Criminal Records Office of the Trinidad and Tobago Police Service in the CID. And this has to do with, and these officers, they conduct checks into bail applications made before judges in chambers, not in the public court. This is by judges in chambers who deal with applications for bail on a daily basis. And these officers conduct the checks on behalf of the state in satisfaction of the judges in chambers. And these figures are for the period 2019 to 2022, where applicants were refused bail due to conditions imposed under sections 5.2, 5.3, and 5.5 of the act that we are seeking to expand today. So they are germane to this. They are the kernel of the nut. This is not an emotional issue or shouting issue. These are the hard facts. And they deal with this in accordance with the very Act number 17 of 2019. It is noteworthy to mention that these bail officers of the CRO, Criminal Records Office, are involved in the preparation of police reports and criminal records on behalf of the Office of the Director of Public Prosecutions in the hearing of these applications before the judges in chambers at Port of Spain, at San Fernando, and Tobago. I now share with you applicants who were refused bail by judges in chambers for the period 2019 to 2022. 2019, 18 of them were refused bail. And that would be 18 out of thousands, because the judges, on the basis of what is in front of them, are the ones who make these decisions. In 2020, 46 of them were denied bail. In 2021, 46 again. And so far in 2022, 13 have been denied bail when the judge sitting quietly in chambers would have heard submissions from attorneys representing them who will put their best case for their clients, and of course the state supported by these officers of the CRO through the office of the DPP. A total of 116 refused bail. The number of persons refused bail who had criminal records for serious offenses and were subsequently charged for another offense, which is what we are dealing with Act number 17 of 2019, which is in front of us today, are as follows. In 2019, there were 17 of them, all of them with over 5 pending matters for similar serious offenses. In 2020, 23 of them, 17 of that with persons over 5 pending matters for serious offenses. In 2021, 33 of them, 10 with over 5 pending matters for similar serious offenses. And so far in 2022, none have appeared with over 5 pending matters for serious offenses, a total of 79. These are records. And these are small numbers compared to the number of persons who commit offense. Other statistics have shown, and I might refer to some of them, the numbers of persons who commit offenses. But on the question of bail before judges in chambers, these are the facts. And this is what the measures in front of us are getting to deal with persistent, repeat offenders who kill us, rape us, burn our businesses, kidnap our family, and demand money with menaces. As I said, this is not about me or you. It's about the public who we are here to serve. And that's why we have to take a professional, non-egoistic, non-partisan, non-emotional. What we have to tune into is, what does the public want of this parliament? That's the issue. Because it is a fact that Trinidad and Tobago, like many other countries in the world, have become a dangerous place. I just saw on my phone officers of the transnational crime here detecting a major amount of cocaine on the shores of Trinidad and Tobago. Just saw it, reporting to me as minister. And I am aware, and this is not about me, but as minister now, information comes to hand which tells me we are in a dangerous place. And that people, as a consequence of that danger, are at severe risk, and it is my responsibility and the responsibility of all of us in national security to improve our border security. And we had a success this morning working with our international partners from the report I just got. And of course, you would have heard me announce, Madam Speaker and the Commissioner, Madam President of Police. The police have embarked upon a very active and sustained gun retrieval exercise because there are many thousands of illegal guns in Trinidad and Tobago, sneaked in by people, including officials of the state, yet to be detected and found and prosecuted. Some have been, but it is a work in progress. It's always happening. And of course, the criminals, for whom this is a lucrative business with no concern for the public interest other than to make money unto themselves, they work 25 hours a day. So you would have heard me demanding more and more of the police service, more and more of the defense force, again in the protection of the public interest as Minister of National Security. But in this place, as Parliament, we too have a responsibility. And I want to repeat, it is not mine, not my interest, not yours, nothing personal, nothing political. What we are called upon to do is for us to use our intellect, use our minds, use our knowledge, all that we bring, and gauge the public interest and represent that public interest in fairness to the people of Trinidad and Tobago inside or here. You're not doing it for me or for the government. And therefore we went...
Minister, I think Senator Thompson wants to ask you a question.
Mr. Minister, can you tell us a similar provision in another jurisdiction with this law?
What I do know is that in all countries of the world they have judicial systems, and in all countries of the world there are dangerous people, and in all countries of the world there are prisons, and in all countries of the world there are courts, and in all countries of the world there are judges, and the idea of having people in custody who are dangerous is normal. I can't tell you anything specific about Jamaica or Barbados, but what I can tell you...
Senator Lutchmedial, you had your opportunity, please.
...is that these laws exist in countries all over the world.
Just 1 second, Minister. Minister of Culture, Tourism and the Arts, and Senator Lyder. If you all want to have a conversation while the minister is making his presentation, you're free to leave the chamber. Okay?
And so I am, you know, those are the facts. Those are the facts. And they do exist in other countries to protect the people of those countries. In fact, in some countries, in Guantanamo Bay in Cuba, men who were allegedly terrorists were kept. Not the best example, but there are countries in the world who see it necessary to do that. In the United Kingdom, they had 18 persons who they detained during those heady times, just after 9/11. So I could tell you, and these matters will be tested in court, but all countries have issues to deal with. And they do deal with them. In addition to all that I've just told you, I have knowledge as Minister of National Security of the ongoing daily attempts at persons who are in custody sent there not by the government but by the courts of Trinidad and Tobago, independent courts, who try hard and want to come out. They use all manners of ways to come out because their liberty is restrained and they want to be out here, but they went in the first place because of acts that are allegedly committed, and they were charged for certain offenses, and the courts say that you should stay there for one reason or the other. I know of prison officers who were, at least 2 cases, prison officers, not 2, several prison officers killed because of prisoners who want to come out. And these prison officers stand firm by their oath and acting in the public interest. They put their lives on the line. They receive threats on a daily basis. In one of the cases the member spoke about a while ago, it was a case, ended up in the Privy Council, where a prisoner inside the jail killed another prisoner. And I only say those things to demonstrate that people who are in custody want to come out. The other day we had a domestic violence killing in this country, the name I can't remember now. But this was a man who was on a restraining order, who the court say you should not go around the lady, and so it was. He went and killed her. There are people like that. And in the public interest, we have to protect the public from them. And this is what this is all about. So the senator who spoke before me spoke about, imagine a man inside of the jail for mere suspicion. That's what the senator says. And she spoke to one of them who told her he lost his family, he lost his job. No concern about separation of powers on that occasion, because it's not the parliament that sent them there, it's not the government that sent them there, it's the very court. The judges are the ones who have the discretion. And while she was telling us about that man, she made no reference to what he had allegedly done, which house he burned down and displaced 4 children, somebody else 4 children. And somebody else don't have money to buy another house or build another house. No reference to that, but it was convenient to describe it as mere suspicion. Tell the woman who gets raped, and then, as I know, report it to me. When she wants to go to the police station, tell her, if you go to the police station, we will burn down your house with your grandmother and your child in it. And I'm begging her to go to the police station and make a report. Tell the person who lost their 2 sons recently in a certain part of this country, they're never to be seen again. And they're crying and they're grieving, but they wouldn't dare grieve in public because they know the source of the problem. Madam President, the senator, and that's the reason why we are here, to balance the public interest and for Parliament to give expression to the public interest. That's why we are here. The senator spoke about prison conditions and quoted a case from 2008. We are in 2022. A lot has happened since, including a term of government by those on the other side for 5 years and 3 months. A case from 2008. Well, I'm happy to let senators in this parliament know that since then, we embarked upon trying to fix the conditions in the prison to meet the high and proper constitutional standard that Justice Gobin and others have spoken about in 2008 and thereabout. So I can tell you as Minister of National Security that we have expended millions of dollars and completed all the refurbishment on the south wing of the remand yard. And we are conducting works as I speak, due to be finished very shortly on the northern wing. Many and all, or the slab bucket of which she spoke, no more. Because in those refurbished cells, They are air-conditioned, proper ventilation, proper painting, proper lighting, and toilets inside of those cells, so that the question of slopping out is gone. 2008 she's talking about, a long way behind the reality. But they do that, Madam President, in order to stir the emotions that they seek to stir. My colleagues on this side would have given statistics about reported firearm-related murders. Altogether, between 2015 and today, 2,820 of them. And every bullet from the thousands of guns can have lethal and deadly effect, only waiting to erupt when the occasion arises. And this is why the police service has embarked on this sustained, intense, and focused gun retrieval exercise to protect the people of Trinidad and Tobago. That's their job. And again, up to this morning, I received a report from the police about 3 AR-15s they recovered. And the work continues, which is why we bought those OPVs, and which is why we bought those 2 vessels recently, so that they could parade our coast and protect our people from those who do not seek the public good, as we are called upon to do in this House. Insofar as gang-related murders is concerned, these figures were shared with you already. 1,181 gang-related murders according to CAPA. Gang-related murders with firearms from 2015 to today as we speak, 1,159. Very serious matters to take as we replace our egos and our political party postures with gauging the public interest. And firearms found and seized by the police between 2009 and 2022, as I speak to you now, 8,831 seized by the police. And I account for about 6 of them, in fact about 8, where people in my constituency call me and tell me, look, they want to get rid of this, they want to change their life, and I report it to the police, and the police take action. I could boast of that, but now is no time for boasting. I did that in the public interest, and I'm proud of it. And firearm-related offenses from 2009, 24,574, and of course arrest for possession of firearm, because sometimes the police get the firearm, but they ain't get the man with it. 1,984 of them between 2019 and today as I speak to you, Madam President, in the public interest. Nothing to do with me, nothing to do with the government that I am proud to be a part of. All to do with protecting the public interest. Madam Speaker, the senator before me spoke about this being unconstitutional. Well, there's the case of Achille Charles, which the Court of Appeal, led by Mr. Justice of Appeal, as president of that court, Mr. Ivor Archie, our Chief Justice. That matter is on appeal. I had the opportunity and the benefit of reading it as an attorney at law, as a literate and conscious man. And I was very impressed with the logic and his judicial astuteness in coming to the conclusion that attempting to restrict bail would have been interfering with the separation of powers, because that ought to be left to the judges. The judiciary has its responsibility. The Parliament, on behalf of the public interest, have ours. And there's always this uncomfortable battle. That matter is not yet concluded. It is on appeal to the Privy Council. And the argument in that is whether the courts can grant bail for murder. They so found, and the matter is now on appeal, and we must wait to hear what our old colonial masters and the court that is still our superior court of appeal has to say. Finally, the message comes down to us. They said in that case it has always been so that the courts should be the one to decide, and that it would be an encroachment on their powers. The senator carried that argument here today, but that matter is on appeal. But in the meantime, while that was happening, In the case of Dominic Suraj, which the Attorney General opened this debate with and spoke about it at least twice in this Parliament, in the other place, within recent weeks, in that case, the matter of separation of powers and the power of Parliament was all put out for attention. And this case says, and he quoted it, and I am only repeating some of it because I want to speak to the people who we claim to represent and to remind the Honorable Senator who just spoke before me. Hear what they say in paragraph 91. Just a short quotation, if you would permit me. The stronger the public interest is in the issue, the greater the interference with individual rights which may be permitted without there being any violation. Generally, in a democracy, it is democratic institutions, of which this Parliament is the supreme, which have the primary responsibility to identify the public interest and what is required to promote it. I'm quoting from the very Privy Council in the Dominic Suraj thing. The AG quoted it already. It goes on to say in another part, Parliament will have identified in a particularly clear and forceful way its opinion as to where the public interest lies. It's Parliament have to decide that. In a democratic state, the courts must be expected to be especially respectful of the choice made by Parliament to pass legislation in that form, and hear this, Madam President, and slow, to substitute their own view of the necessity for and the proportionality of the measure taken. That is what the Privy Council telling us. Independent Trinidad and Tobago, former colonial stronghold for the British. It is the British Privy Council, which is our highest court of appeal, telling us that. And some time ago, Lord Keith of Kinkel, perhaps he would have passed by now, I think it was 1991, he was telling us it's time for you to move on and get your own highest court of appeal. As long ago as that. It goes on to say in another part, the proviso in section 13, which is what the senator mentioned, Pasa, about respect for the laws and the rights and freedoms of others. It says the proviso in section 13.1 is a long-stop check against abuse of that power and cannot be taken merely to replicate the ordinary proportionality standard inherent in the rights of section 4. As far as I understand it, and finally quoting from that, it says, it shows that Parliament considers the public interest objective to be very important indeed, which in turn is likely to affect assessment of whether there is a sufficient degree of connection between the measure, like the ones we have today, in issue and that objective. Whether the trade-offs in public policy terms in using that, sometimes called proportionality in the strict sense, whether, yes, the trade-offs in the public policy terms in using that measure as opposed to others are acceptable. And the question at stage 4, sometimes called the proportionality test, the essential, and here's the Privy Council, the essential question posed under the proviso, taking into account this framework, is whether the act in question, like we are trying to pass today, strikes at an acceptable balance between the rights and freedoms of individuals and the general interests of the community. So here is the Privy Council telling us, get on with your business. You have a parliament in this republic, and it is you who have to decide where the balance must be set. So when the senator submits today that any bail restriction in the public interest is in itself and inherently unconstitutional, that I submit is quite wrong. They are telling us it is for you, through this institution, to make that decision, and that the courts must be slow to interfere with that, because you, Parliament, you, honorable senators, have that decision to make. They're telling us effectively organize all yourself. You're an independent nation, sort yourselves out. Don't put your personal interests, we say that in the prayer every day. Don't put your personal interests about others, over others. Don't put your party posture before others. What we seek here is the public interest and balancing the trouble that we face. And striking the right balance, and the court must not easily jump in and interfere with that. That's what the law says. Madam President, as I work to my conclusion, if anyone thinks that this is all the government is providing the police with through this Parliament to fight crime, they are simply wrong. Let me share with you the fact that the police service has been doing work in various communities throughout Trinidad and Tobago through the divisional. There are 9 divisions. Every one of them have a police youth club to circumvent and to discourage young people from going around to gangs and the negative pathways. The prison service have youth clubs. The fire service have youth clubs. The Defense Force manages for years specialized youth training development programs, MyLAT, MyPath, CCC, and others. Every time somebody is having a hike, they get the Defense Force to send personnel to walk around with them, to protect them in the public interest, and to show them some of the elements of their techniques and the discipline. And the government supports that. As you know, we established the Ministry of Youth Development, focusing exclusively on youth. As you know, the education system, we all know it well, designed because only young people is in the classroom, from early childhood to primary school, to secondary school, to university, all young people, offering them positive pathways rather than succumb to the blandishments of the gangsters. So that's one of the tools that we use through the police service. In addition, the TTPS over the last 4.5 years utilized the anti-gang legislation that they reluctantly supported on one occasion and failed to support on another, to arrest and charge a total of 90 persons with various anti-gang. I've heard people glibly and ignorantly say, not a single charge under the anti-gang law. That is simply not true. 15 were charged for being a gang leader. 18 were charged for being a gang member. 16 charges in relation to the Anti-Gang Act. 10 for supporting a gang leader. And 31 other offenses, totaling 19. And that a number of initiatives targeting gangs and gang-related offenses continue. I'm aware. Because we do have dangerous gangs in Trinidad. Whether it's Rasta City, so-called, whether it's ABG, whether it's Sixes, whether it's Muslim, and all the other so-called gangs. We do have them, and they are creating havoc. Another tool that we use...
Minister, you have 4 more minutes.
Good. Special training for the emergency response police, and new strategies, new training, new techniques, so that they could confront these people in the public interest. And I have a very long list of outstanding. I heard the senator say, no DNA. That's not true. In the last year alone, we now have 3 forensic pathologists. We employed 2 new mortuary attendants, making it 7. No long lines outside of the Forensic Science Center on a Monday morning anymore. Even though you have that busy weekend with crime and murder. Ballistics, 21 police officers and 5 employees of the thing trained in ballistics and doing casework. 1,225 backlog cases are processed and cleared up by that little team of 25 or 26 persons. 247 persons cases involving police shootings. You see the Jilks case and all them, the emergencies, and when the masters of the court and the DPP call for it, we have a system now as they call for it, they get in it, not to hold up the criminal justice process. That is happening boastfully, but no, celebratorily. 3,033 firearm holders got their processing because, you have to have it tested and so on. In the biology unit with the DNA, I tell you what, we renovated the building during COVID-19. September 21, the DNA unit reopened after 2.5 years of its being closed. I oversaw that, and right now they're running. And I can tell you, Madam President, solving more and more cases, supporting the police, and you will see an improvement in the solve rate because DNA functioning with almost perfection, the biology units working, they have the resources they need, more persons trained, and they are inside of it. They are inside of it. And 5 police officers in advanced practical and theoretical forensic DNA to bolster what I just told you. We have introduced some new drugs, ketamine, methamphetamines, ecstasy. All of these are new drugs that we have put, and they're now testing for those at the Forensic Science Center. And that was just because time has run, just a small synopsis, which I can boastfully tell you happening. So all of these, including these measures, are just different strategies and tools. So to give the impression that the government is only depending on this is simply misguided. Madam President, electronic monitoring, functioning, and we are in the process of procuring even more equipment for them. So I close by saying, this bill is not for me. This bill is not for the Ministry of National Security. It's not for the government. It is for the people of Trinidad and Tobago to protect their welfare and safety, and it is our decision in this House whether we choose to find the right balance and to protect them or not. I thank you.
Attorney General. Listen, Senator Leiter, please stop. I have already ruled on previous occasions you can leave the chamber, but you leave in silence, okay? Attorney General.
Madam President, thank you very much for this opportunity to wind up what is a very important debate on a very important piece of legislation that this government has brought to this House in the interest of protecting the citizens of the Republic of Trinidad and Tobago while respecting the rights of every member of this society, even including convicted criminals. Madam President, I'm going to spend a little time so that we can renew our focus on the schedules of the 2 acts which are in focus today. The schedule of the 2019 Act and the schedule of that which will come back into force if we do not extend beyond the sunset clause. We remind ourselves, Madam President, of Section 5 of the Amendment Act which is before us today. Section 5, that is to say, of the 2017 Act, which we are seeking to continue in effect for another year. So when we look at Section 5 of Act number 17 of 2019, we are reminded that Section 5 of the Act then amended the Bail Act by repealing subsections 2 and 3 and inserting after subsection 1 the following subsections. So the current subsection 2 to the 2019 Act number 17 of 2019 reads, A court shall not grant bail to a person who, on or after the commencement of this Act, is charged with an offence listed in Part 2 of the first schedule and has been previously convicted of an offence which is punishable by imprisonment for a term of 10 years or more. So we remind ourselves that those persons whose right to bail is circumscribed under the Act currently in force, which we are asking this Parliament to continue for another year, are persons who are already convicted of an offence punishable by imprisonment of a term of 10 years or more. And Part 2 of the 2019 Act, Act number 17 of 2019, was introduced by Section 6 of that Act and reads, Part 2, specified offences. So these are the offences which I draw to the attention of members of this august House, which currently obtain and in respect of which persons charged with offences who have already committed these offences are being circumscribed in their right to avail themselves of bail. A, an offence committed by a person over the age of 18 years under the Anti-Gang Act, which is punishable by imprisonment for a term of 10 years or more. B, an offence under the Offences Against the Person Act, punishable by imprisonment for a term of 10 years or more. C, an offence under the Dangerous Drugs Act, punishable by imprisonment for a term of 10 years or more. D, an offence under the Kidnapping Act, which is punishable by imprisonment for a term of 10 years or more. E, a sexual offence in which the alleged victim is a child. F, an offence under the Sexual Offences Act, punishable by imprisonment for a term of 10 years or more. G, an offence under the Anti-Terrorism Act, punishable by imprisonment for a term of 10 years or more. H, an offence under the Trafficking in Persons Act, punishable by imprisonment for a term of 10 years or more. I, an offence under the Firearms Act other than Section 161 or 2, punishable by imprisonment for a term of 10 years or more. And importantly, J, an attempt to commit an offence listed in this part. So that is the current state of the existing law, Madam President, which was brought into effect by Act number 17 of 2019, which we ask this House to continue for one more year. Those are very serious crimes, Madam President. Our failure, our decision today not to extend the life of that act will cause a reversion of the bail laws to what it was prior to the year 2019. And the detrimental consequence would be the reinstatement of the original Section 5 of the 1994 Act, which provides for the denial of bail for offences where the accused is convicted on 3 previous occasions within the last 10 years. And we should remind ourselves of what Section 5 of the 1994 Act says. Section 5.2, a court shall not grant a bail to a person who is charged with an offence listed in Part 2 of the first schedule and has been convicted on 3 occasions arising out of separate transactions, A, of any offence, or B, of any combination of offences listed in that part, unless on an application to a judge, he can show sufficient cause why his remand in custody is not justified. In calculating the 3-year convictions referred to in subsection 2, only those convictions recorded within the last 3 years shall be taken into account. So we understand immediately, Madam President, that when we revert to the pre-2019 legislation, what we are reverting to in that previous situation is Schedule 2 of the pre-2019 series of offences which specify the following. So this is what we will go back to. Specified offences. A, trafficking in narcotics or possession of narcotics for the purposes of trafficking. B, possessing and use of firearms or ammunition with intent to injure. C, possession of imitation firearms in pursuance of any criminal offenses, D, rape, E, sexual intercourse with a female under 14, which no longer applies as a result of other amendments, F, buggery, G, shooting or wounding with intent to do grievous bodily harm, H, robbery, aggravation with aggravation, armed robbery, I, larceny of a motor vehicle, J, burglary and housekeeping, K, perverting or defeating the course of public justice, L, arson, M, an attempt to commit any offense listed in this part or part 1, N, receiving stolen goods. So that is the list of the specified offenses which this law will revert to should we not pass the legislation, the bill before this House today, to continue for one more year Act number 17 of 2019. Madam President, I say, notwithstanding the very many emotional arguments that we've heard, and I say that with respect, I don't mean any disrespect to anyone, that this reversion would be a very unfavorable step backwards for Trinidad and Tobago when one considers the risk posed to society by persons who commit or are charged with serious crimes and have been convicted of those serious crimes and are once more before the courts and are being asked by this Parliament to operate in limited circumstances under the discretion of the judiciary as to when and over what period of time they are allowed to go on bail until such time as they are fully tried as charged. The 2019 Act, Madam President, covers a two-strike situation, which is wholly appropriate in the context of today's current crime situation. To revert to a three-strike requirement before giving the judiciary the power to automatically deny bail creates, in our respectful view, an unreasonable hurdle, one may say an unforgivable hurdle in the fight against crime. There are reported situations where no objections have been made to bail. Of course, one may say that that is for the police to get their act together, but we have to deal with our reality in pragmatic terms. Part of the pragmatic terms with which we have to deal with our reality, which informs the fact, and I will speak to that shortly, informs the fact that I only this morning got statistics which I have been asking for the past several weeks, has to do with the fact that we are coming out of a pandemic. Our systems are not up to the functional strength that they were prior to the pandemic. So for 3 weeks, I have been asking for statistics to justify the work that has been done in the last 3 years. I got some of those statistics this morning. And I go on record to acknowledge the hard work of the members of the judiciary, the prison service, and the police service, who, working under strained and constrained circumstances, have been able to give me that information today, have been able to give it to the Honorable Minister of National Security so he could have spoken to it this morning. We are not living in a perfect world. We are attempting on an incremental basis as a responsible government to keep this society safe, not to condemn ourselves to emotional appeals to create a crisis so that there can be some pretend basis to say the government has failed and voted out of office. Because when we do that, we are being reckless and we are exposing the citizenry of this country to the downfall of not being a responsible parliament. Madam President, what is equally worrisome with reference to the specified offenses to which the former Section 5 applies when compared to the updated and comprehensive list contained in Part 2, is that we immediately appreciate when we lay Schedule 2, Part 2 of the pre-2019 Act, alongside Schedule 2 of the Act number 17 of 2019, we immediately see the difference in the scope and application of specified offenses which currently forms the law of this country and captures a wide range of criminality under, for example, the Dangerous Drugs Act, Kidnapping Act, Trafficking in Human Persons, and Sexual Offences Act. This as opposed to what is listed, and I have listed it under the former Section 5, which included mere references to a few identified offenses, such as trafficking in narcotics and burglary, and matters which may carry a penalty of 10 years or more. Madam President, additionally, Part 2 of the 2019 Act includes offenses which have been recently included into our body of law, such as the anti-gang and anti-terrorism offenses. These are serious offenses, and we cannot, with the greatest of respect, because we got the statistics late today, and I know it was a matter of legitimate concern, in particular for the independent senators, that we weren't able to put statistics to show what difference has been made in the last 3 years. But now that we are able to show some of those statistics, we cannot, with the greatest of respect, risk rolling ourselves back to a pre-2019 criminal justification basis to allow convicted criminals to roam the streets while they are being charged and are before the courts on similar offenses and continue to pose a risk to our young women, our children, our vulnerable, our elderly, and our right to walk our streets safely and to live in the comfort of knowing that the judicial system, the prison system, the governance of this country places the priority of the safety of all citizens as the foremost priority. Madam President, I have already in my pilot referred to the criminal justice system improvements which the Ministry of the Attorney General and Legal Affairs is engaged with, has accomplished, and continues to engage with. And may I go on record once again to pay tribute to the very hard-working members of the teams within the Ministry of the Attorney General and Legal Affairs. I have been humbled, I have been privileged to have assumed the office of Attorney General and to be served by persons who work until midnight, most nights, to provide the Attorney General with the material by which he can advise the Cabinet and the government on responsible governance, and I thank them. I have spoken in my pilot, Madam President, to the holistic approach to governance which this government must take. So today, when we speak to this Parliament to ask the Parliament to support the government to continue the legislation for one more year, we are not just speaking to one piece of legislation. We are speaking to a suite of legislation. And I will give just one example of the suite of legislation which is currently a work in progress, which I have inherited, which is part of the suite of legislation that we are bringing to this Parliament to keep our citizenry safe, of which this piece of legislation, this bill today, is only one. So we are working on the Offences Against the Person Amendment Act, categorization of murder, the Administration of Justice Indictable Proceedings Amendment Number 1 Bill, deeming of indictments, the Anti-Terrorism Amendment Bill, returnee bill, to deal with returning persons who have found themselves out in societies such as Syria, the Interception of Communications Amendment Act 2020, the Criminal Records Rehabilitation of Offenders Bill, to find a way to give an opportunity for rehabilitation to persons convicted of crimes. The Miscellaneous Provisions Trial by Judge Alone Bill 2021. The act that we dealt with yesterday in the House, in that other place, the Miscellaneous Provisions Criminal Proceedings Bill, abolition of the year and a day, and relaxation of the rule against double jeopardy. All of that being a work in progress alongside with, simultaneously with, the bill that is before the Parliament today. The Miscellaneous Provisions Testing and Identification Bill 2019, polygraph testing, the Controlled Deliveries Bill 2022, the Firearms Amendment Act 2021 for regulation of the use of pepper spray, the Arbitration Bill in the civil jurisdiction to increase our capacity to resolve our disputes without always having to resort to the adversarial system of our justice system. Trafficking in Persons Amendment Act to seek to deter the commission of human trafficking offenses and to provide better care and protection for victims of trafficking. The Parole Bill A comment was raised justifiably by a member of the independent bench. What about parole as part of the suite of legislation that we should be concentrating on, as opposed to simply trying to extend the sunset clause of the legislation, Act 17 of 2019? Work is being done on that as part of the comprehensive suite. The Evidence Amendment Act Number 2 bill, witness anonymity orders to protect witnesses who have to live in fear of their lives when they have to come forward to give evidence in our criminal justice system. All of that, Madam President, is part of a suite of legislation which is being worked on in tandem with that which we have brought before this House today. The Minister, the Honourable Minister of National Security, has spoken to the improvements in the forensic science data, Forensic Science Center data, and I had intended to list that as well, but I am not going to because he's already been there. But the point is, we are working on an ongoing basis to improve our capacity to deliver justice, to provide for expeditious justice, to provide for empirically reliable systems and processes to bring offenders to justice, and to give a measure of psychological relief to the relatives of the victims of criminal activity who will know that their loved ones have been lost, maimed, or wounded, but that the justice system is working to bring the offenders to account. It is part of a work in progress. It is not simply one piece of legislation and therefore strike it out and embarrass the government into allegedly failing to combat crime so that other persons can have themselves celebrated for crying loudly, and sometimes one might say crying wolf. That is not how we govern responsibly, Madam President. Madam President, the statistics which I received today, I am able to tell this Honorable House, only this morning at about 8:30, having been asking for this information for the past 3 weeks, knowing that we were coming with this bill to the Parliament, knowing that we have a sunset arriving on the 5th of August, and we would be asking the legislators in this Parliament to do the responsible thing, to continue the legislation, because it is our view that that which we have already passed has begun to take effect, is being applied, and therefore it is justifiable that we ask senators in this August House to take that one further step, to give us that little bit more time in which to keep the men and women, the citizens of this country safe. I have been asking for it. I got it this morning, Madam President. It goes some small way to demonstrate that Act number 17 of 2019 truly captures repeat offenders. When I go through Schedule 2 of Act 17 of 2019, we are talking about repeat offenders. Yes, they have rights, and we have to respect their rights to due process, but they are repeat offenders from whom we want to keep this society safe. So it goes some way to demonstrate that the Act which is now in force and which we ask to extend captures repeat offenders and persons intent on repeating their criminal conduct. And we are saying that the data which has been provided illustrates that persons who were denied bail due to the conditions imposed under Section 5, 2, 3, and 5 of the Bail Act 17 of 2019 is working. The Criminal Records Office has pulled data from bail applications done before judges of the Criminal Division of the High Courts in Port of Spain, Tobago, and San Fernando. And I thank the Criminal Records Office. This category of data is important as it is reflective of persons who were firstly denied bail at the magistrate's court, or persons who may have been granted bail and who have now come before a judge in chambers to reapply for bail. The data shows that the total number of persons who were refused bail by a judge in chambers for the period 2019 to 2022, that is to say the application of Act 17 of 2019, totals 116 repeat offenders. Interestingly, Madam President, those 116 persons, of those 116 persons who were refused bail, 79 persons had as part of their criminal record over 5 additional pending matters for serious criminal offenses. Not 2, 5 additional pending matters for serious criminal offenses. And I'm not going to belabor the repetition of Schedule 2 to the 2019 Act to remind ourselves what those serious criminal offenses are. That is a percentage, Madam President, of 68% of persons who were denied bail with this legislation in place over the past 3 years and have had several pending matters for serious criminal offenses. Madam President, I was at pains when I piloted this bill on Monday to illustrate that the Act 17 of 2019 is truly intended to target repeat offenders. I was at pains to illustrate that the persons being denied bail before the courts and the persons within this country contributing to the increasing crime rate do, in fact, and as a matter of court record, have a history of criminality. Yes, they have rights, and yes, we must respect their rights. We must give them access to the judiciary so that the judiciary, in due course, can adjudicate on their guilt or innocence on the new charges that they find themselves before the courts for. But we must give the judiciary in our less than perfect system time to process everything, and all we are saying is postpone their ability to apply for the bail whilst the system works through to ensure that those persons are not immediately allowed back onto the streets. So that the Act, Madam President, Act 17 of 2019 is working with the limited statistics that we have received in the constrained circumstances of the pandemic, which tells me certainly that the statistics may yet show more, but for purposes of this debate today, to appeal to the responsible members of this Senate, I think that we can say with confidence that we have put sufficient material on the simple statistics of 2019 to 2022 to show that the legislation which we are asking this Parliament to continue has not existed in a vacuum, has not existed as if nothing was done. Work has been done, work is being done, and in the meantime, the citizenry of this country are being kept as safe as we possibly can by a process of responsible governance. Madam President, as Attorney General with a commitment to progressive bail reform, I am optimistic that extensive consultation on comprehensive bail reform is critical. I commit to that, to include the Council of Criminologists with whom I have already engaged, because crime is not a phenomenon that is distanced from or separate from the society which gives birth to crime. Crime is a product of who we are and how, therefore, we must fix ourselves. And in the process of governance, we have to work at our societal improvements. We have to work at improving the quality of life for every citizen in the houses that they live in the streets that they walk in the schools that they go to, and that is what this government is committed to. And in the meantime, we, as a part of the criminal justice system, the part of the civil justice system, part of the administration of justice, are committed to doing the little that we can to come before this Parliament with properly drafted law to say to this Parliament, we need that little bit more time. A question was asked, Madam President, and I will turn to it immediately. A question was asked whether or not there are any precedents to this legislation. Well, I can say with confidence, Madam President, that, and I'm not going to cite them as precedents because I do not. I am not one of those lawyers who speaks glibly or without research and claims to know everything and every answer. I speak guardedly, and I speak with the maturity and the humility to know that I may be wrong. So I'm not going to misrepresent what I'm about to say, but I can say that there are other jurisdictions which are looking at their bail laws. New South Wales, Jamaica, Barbados, St. Lucia, Australia, and New Zealand are looking at their bail laws to amend their bail laws to refuse bail in limited circumstances so as to keep their citizens safe. We are not out there flying a kite because we are irresponsible and seeking to just keep people in prison. We are looking at the precedents to assist us in the responsible drafting process. And may I digress for a moment, Madam President? I got a text message last night from an attorney general of another country in the Caribbean asking if I knew of any good, serious draftspersons because they need draftspersons. And I was able to say to them with pride, we have very good draftspersons in Trinidad and Tobago. And as much as I'd like to offer them to you, Mr. Attorney General, I said to my colleague last night, we have work for them to do in Trinidad and Tobago so that when we come to this Parliament with a bill such as that we put before this Parliament today, we do it with the confidence of knowing that it has been carefully drafted with reference to safe precedents, and we are asking the legislature to have the confidence in knowing that when they pass the legislation drafted by our Chief Parliamentary Counsel and his staff, it is responsibly drafted legislation, and I commend them. I digressed, and I beg your forgiveness, Madam President. We are committed to an ongoing criminal justice reform system which will keep this society safe. We, and I can speak for myself, I intend in the period that we are asking, that one more year, to return to this Parliament with more legislation with a view to looking at our bail reform generally so as to take a holistic approach to bail generally. My good friend and colleague in this Parliament, Senator Vera, made some very interesting remarks on Monday, and I regret that he's not here with us today so that I can speak with him directly, but I know that he will pay keen attention. He made a number of suggestions for improvements in the legislation, which I am happy to say, some of which is already addressed in the very legislation that we are asking this Parliament to continue today beyond the sunset. So Senator Vera said on Monday that he would like to see community provision for community safety to ascertain whether or not the accused is likely to pose any threat to the society, and that ought to be a factor to be considered by the magistrate or judge when deciding whether or not to grant bail. Well, Section 2A1, Roman 2, Section 2A, Roman 2 of the legislation before us says, where the offense or one of the offenses of which the defendant is accused in the proceedings is punishable with imprisonment, it shall be within the discretion of the court to deny bail to the defendant in the following circumstances. A, where the court is satisfied that there are substantial grounds for believing that the defendant, if released on bail, would commit an offense while on bail. So that is already under consideration in this legislation, and we are going to improve it in the return that I promise we will make to this House on a more comprehensive bail reform. Senator Vera spoke also of wishing to see provisions for that employment of the accused ought to be a factor to be considered by the magistrate or judge when deciding whether or not to grant bail. Section 3B of the legislation that exists at the moment, which if we don't renew it will roll back, provides that in the exercise of its discretion under Section 2A, the court may consider B, the character, antecedents, associations, and social ties of the defendant. Senator Vera said that the family of the accused ought to be a factor to be considered by the magistrate or judge when deciding whether or not to grant bail. Well, under the present legislation, which we are asking this Parliament to continue, the judges have the discretion to grant bail within the prescriptions of the legislation. And one of the things that is prescribed for in Section 6(3)(b) is that in the exercise of its discretion under subsection 2A, the court may consider the following: the character, antecedents, associations, and societal ties of the defendant. He spoke to looking at community relations. Again, that will come in under Section 3B. And we have the catch-all phrase at the end, Section 6(3)(e). In the exercise of its discretion under Section 2A, the court may consider the following: any other factor which appears to be relevant. So that far from denying the judicial system oversight of the circumstances in which to grant bail, the existing legislation, which we ask this Parliament to continue, provides for some of the very considerations that legitimately trouble some of our senators here, and which this government commits to coming back to improve on in a more holistic manner, with the advice of relevant experts, including those criminologists that I have already begun speaking with, because I appreciate that it must be a societal product that speaks to who we are as a society from a proper socio-psychological and criminological basis. Madam President, Senator Lutchmedial today sought to suggest, and I say immediately wrongly, that if this legislation is continued today, it will be an exercise in futility. My words, exercise in futility, because the Senate is being asked to pass illegal legislation. Well, that is, how shall I find a polite way to say it? A misrepresentation which I would expect on a more careful read of the law, Senator Lutchmedial would correct herself on. In the first instance, the Achille Charles decision, which is on appeal to the Privy Council, doesn't concern what we are debating here today. The Achille Charles decision concerns Section 5(1) of the Bail Act. I only have to go to paragraph 1 of the decision in the Achille Charles decision of the Court of Appeal, the judgment of Chief Justice Ivor Archie, which is now on appeal and which the state has argued forcefully should be overturned, but that's another point. This is what Chief Justice Archie began his judgment with, paragraph 1 of his judgment dated the 17th of February 2022. The central issue in this appeal is whether Section 5(1) of the Bail Act of 1994 is inconsistent with the Constitution and therefore susceptible to being struck down. Let's look at the Act. Section 5(1) deals with the category of offenses specified in Part 1 of the schedule, which are murder, treason, and piracy. It does not have anything to do with Sections 5, 2, 3, 4, and 5, which we are considering under Act 17. So I have every confidence that when Senator Lutchmedial reads the Achille Charles Court of Appeal decision, she will correct herself. Secondly, there is the decision of this very court, Madam President, a Court of Appeal decision, Civil Appeal P351 of 2016 between the Attorney General and Daniel St. Omar, a decision, a unanimous decision of Justices of Appeal Gregory Smith, Prakash Musai, and Peter Rajkumar, I beg his pardon, dated the 8th of March 2019. And I will read paragraphs 1 to 5 in the time left to me. The central issue in this appeal involves the court resolving an apparent conflict between two sections of the Bail Act, Chapter 4, number 60. Those are Section 5.1, we remind ourselves, murder, piracy, treason, and Section 5.5b2, other aspects of Schedule 2, which we are concerned with dealing with serious crime. Paragraph 2. Section 5.1 is a statutory affirmation of the constitutional right to bail, except as provided for in Sections 5.2 and 4. Section 5.5b2 purported to take away the right to bail in certain cases. That's what we are about today in the discussion we are having, that Sections 5.2 and others have limited the right to bail in certain other cases other than murder, treason, and piracy. Paragraph 3. An interesting twist to this appeal, I'm reading from the judgment of Mr. Justice of Appeal Gregory Smith. An interesting twist to this appeal arises because Section 5.5b2 was one of some temporary amendments to the Act at the time. Those amendments were in effect for only about 1.5 years. They lapsed on the 15th of August 2016. They were part of what is termed a sunset clause. Section 5.5b2 was no longer the law at the time of the hearing and determination of this constitutional motion in the High Court and on this appeal. Nevertheless, those appeals are not academic because the respondents were adversely affected since they were unable to secure bail, and two, counsel for the appellant informed us that the construction of this legislation may provide guidance in respect of future legislation on this very important area. In summary, paragraph 5, judgment of Mr. Justice of Appeal Gregory Smith. In summary, we find that on the relevant principles of statutory interpretation, the constitutional right to bail in Section 5.1 was not taken away by Section 5.5b2. As a result, neither respondent was deprived of his or her constitutional rights, and we therefore allow the Attorney General's appeal. The short point being there that the challenges to the sections after Section 1, which limit the right to bail, are not unconstitutional because of Section 5.1, which is not what is being challenged in this amendment and not what is under consideration. So I have...
Attorney General, you have 5 more minutes.
Thank you very much, Madam President, and it is perhaps the only time since I have had the privilege to speak before you, Madam President, that I might yet go to my full time. So that I say without fear of contradiction, Madam President, the following few things in summary. The legislation which we are asking this House to extend for 1 more year is legislation which we need in order to continue the work which the statistics that I have read out today demonstrate is a work in progress. Point 1. Point 2, nothing in the legislation that we are asking this House to extend takes away the constitutional right of convicted persons to their right to bail before judges of the Supreme Court or the Magistrates' Court. It just simply does not. It constrains the right to appeal, to bail, but it preserves that right on regulated terms. And thirdly, I say that if we do not continue the legislation, we will roll back the hand of the clock and expose our citizenry to a very dangerous state of circumstances, which the opposition is happy to point to as heralding some measure by which we should govern when they point to the criminality that is taking place in the streets. The point is we cannot afford to expose our citizenry to that level of criminality where we have the means and the resources, the wisdom and the intelligence to do otherwise, which we are asking this House to do. And lastly, I say, Madam President, that I give the undertaking to the members of this Senate that in the year that we are asking for, I will be coming back before this House to ask this House to join with me in a comprehensive system of bail reform that will satisfy the rights of every citizen of this country. And with those few words, Madam President, I beg to move.
Honourable Senators, at this juncture, the sitting will be suspended for 15 minutes and we will return at 12:50 p.m., which is at 10 to 1. So the sitting is suspended until 10 to 1.